Hi, I'm Roy Magara, Solicitor Advocate at Magara Law. When people hear the phrase sexual harassment at work, they often picture a female employee being harassed by a male colleague or manager, but that's not always the full picture. Men can also be sexually harassed at work, and in many cases it goes unreported because of embarrassment, stigma, or fear of not being taken seriously. Many men worry that if they complain, people will laugh it off, and some fear that they will be seen as weak. Others think that the law will not protect them in the same way that it protects women. However, a Government Equalities Office research in 2020 found that men were almost as likely as women to report workplace sexual harassment, with 27% of men and 30% of women in employment saying that they had experienced some form of sexual harassment in the workplace or a work-related environment in that previous 12-month period. So this is not a theoretical issue. It happens, and it happens more often than many people realise. But the Equality Act 2010 makes it very clear that sexual harassment protections apply equally to everybody. Sexual harassment is unwanted conduct of a sexual nature which has the purpose or effect of violating someone's dignity or creating an intimidating, hostile, degrading, humiliating or offensive environment. That can include sexual jokes or comments, comments about appearance or body shape, unwanted touching, inappropriate messages or images, repeated flirting after somebody has said no, or workplace banter that often becomes uncomfortable and crosses the line. In practice, this can be quite varied. It might be colleagues making explicit jokes in a group chat, or repeatedly commenting on someone's physique in a way that feels intrusive rather than complimentary. It could be a manager sending late-night messages with a sexual tone, or sharing memes, images or videos that are inappropriate in a work context. Now, sometimes it is more subtle. Comments about masculinity, sexual performance, or assumptions about someone's sexuality can fall within this definition if they create that uncomfortable or degrading environment. Physical behaviour can also be relevant. For example, standing too close, unnecessary physical contact such as shoulder grabbing or back slapping that crosses into something more personal, or joking about attempts about physical interaction that aren't welcome. Now, importantly, context matters. What might be brushed off can become problematic if it is often repeated, or it escalates over time, or if it continues after someone has indicated, whether directly or indirectly, that it is not welcome. The law does not require the behaviour to be overtly aggressive or extreme. It is enough that, viewed objectively and taking into account the individual's perception, it has the effect of violating dignity or creating an offensive or hostile environment. A lot of cases involving sexual harassment towards men do not involve one standout incident. Instead, it is often repeated low-level behaviour that builds over time. The sorts of comments that are brushed aside as just a laugh, the sort of touching of behaviour that is dismissed as harmless, the sort of culture where someone feels pressured to go along because with it they do not want to become the centre of attention. Now, tribunals increasingly recognise this dynamic. Just because someone laughed along at the time does not mean that that conduct was welcome. Employees often cope by trying not to make a fuss, and the law understands that. Now, this is particularly important for employees and employers because harassment policies and workplace training are often written in a way that assume often women are victims. Now, this can create blind spots. Managers need to know that complaints from men must be taken just as seriously. For employers, the practical steps are straightforward. Make sure your harassment policy is gender neutral. Train managers to recognise that men can be victims too. Don't dismiss complaints as banter. Keep proper notes, investigate promptly, and consider interim steps where needed, such as separating the employees involved or adjusting reporting lines while the matter is investigated. For employees, the key practical advice is this: keep a record. Note what happened, when it happened, who was present, how it made you feel. Save messages, screenshots, emails or images If you feel able to do so, make it clear that the behaviour is unwanted, and if it continues, raise it under the employer's grievance or harassment procedure. Ignoring it because he can handle himself is not only poor practice, it can also expose an employer to legal risk. Now, the legal test is not whether the person complaining about is male or female. The question is whether the conduct was unwanted, whether it was sexual in nature, or whether it violated dignity or created that intimidating, hostile, degrading, humiliating, or offensive environment that I spoke about earlier. So, is sexual harassment towards men at work a thing? Yes, absolutely. And employers who fail to take it seriously may find themselves answering that question in an employment tribunal. At Magara Law, we advise both employers and employees on workplace harassment issues. For employees, we can help you understand whether behaviour may amount to sexual harassment, guide you through internal complaints, and advise you on tribunal claims where necessary. For employers, we help you review harassment policies, deliver training, and support investigations so complaints are dealt with fairly and properly. If you're facing a workplace harassment issue, speak to Magara Law.